11C. Then she vanished, and the real unraveling began. Victoria was sitting at a quiet corner table in a cafe 4 blocks from Arcshire headquarters, one of those third-wave places where the chairs were reclaimed wood, and the coffee came with a paragraph about its origin story. She wasn't there for ambience. She was there for the Wi-Fi, the line of sight to the front door, and the peace of watching rich tech guys panic through Bluetooth headsets. She sipped slowly, checked her phone, and there it was. From Meredith Liu, lead board counsel subject. Clause 11C acknowledged time, 10:41 a.m. Victoria, we are currently reviewing your termination file and contract clause 11C. Your annotated documentation has been received. Timestamp confirms delivery. Will advise shortly. No apology. No flattery. Just cold. Clipped legalese, the kind that meant they'd realized she hadn't been bluffing. She smiled, then opened her encrypted backup app. 3 versions of her contract sat there, as pristine as the day they were scanned. Every page annotated. Every signature clean. Every single initial from Brian, Karen, and 2 members of the compensation committee logged, timestamped, and filed, complete with location metadata. She even had a screen recording of the Zoom meeting where the final equity plan was approved, complete with Brian sipping rosé and saying, yeah, whatever legal wants, just get her to stay through year-end. Across town, on the 44th floor of Arcshire HQ, Meredith slid the packet across the glossy conference room table with the kind of gentleness you'd use to hand someone a live grenade. Brian picked it up lazily, like a man swatting away a housefly. This again? He muttered. She's bluffing. She's not bluffing, Meredith said flatly. She's executing. Karen was in the corner, arms folded so tightly her fingers were turning purple. But if we already fired her, you didn't void the bonus, Meredith interrupted. You activated it. The clause explicitly states that termination without documented cause within 24 hours of a scheduled equity vest triggers accelerated payout terms. Brian blinked. We did that before it vested. That's the point. Meredith tapped the packet. You did it within the 24-hour trigger window. The clause doesn't just cover the moment of vesting, it protects against any last-second maneuvering. And you initialed that language yourself. Page 4, lower right corner. Timestamp 12:43 p.m., February 19th, during your Q4 board session. Brian's face dropped half an inch. No one reads that stuff. I thought legal was just being thorough. Meredith didn't even blink. We were. He flipped to the page, scanned it, and visibly flinched. Jesus. She also submitted her full termination file to Aaron Patel and Sarah Clark within 90 minutes of leaving the building. She has a digital trail that shows she notified 3 internal channels before your department even uploaded her exit memo. Karen let out a choked laugh. She was planning this. Meredith looked at her. Eyebrows raised. She was planning not to be robbed. Big difference. Back at the cafe, Victoria leaned back in her chair. It was that rare, electric feeling, vindication, but still wrapped in silence. The moment right before the world admits you were right. The pause before the storm understands it's about to rain in the wrong direction. Her phone buzzed again. From Sarah Clark subject. FYI clause language circulating time. 11:07 a.m. Meredith has forwarded your clause file to the compensation committee and external counsel. Things are moving quickly. Not everyone is happy. Stay alert. Victoria tapped out a simple reply. Understood. Let me know if they attempt to amend anything retroactively. I have version history on every doc. Then she closed her email, opened a crossword puzzle app, and got to work on a 7-letter word for poetic justice. Inside Arcshire, Brian was pacing now. So what's the damage? Meredith flipped through her notes. Standard payout was $4 million. Clause 11C adds a multiplier based on remaining unvested equity, plus a penalty for premature termination without cause, plus damages if she seeks arbitration. Ballpark it, he snapped. 6.5, she said, eyes cold. Assuming she doesn't push for more. Brian turned to Karen. You said this would save us money. Karen's voice was barely above a whisper. It was supposed to. They sat in silence. Then Brian muttered, fine, offer her a severance package, something clean, half of it, NDA, whatever it takes. Meredith didn't move. She already turned it down. What do you mean? She never asked for settlement, Meredith said. She didn't even ask for mediation. She just submitted the clause, the timestamps, and the chain of signatures. Karen swallowed hard. Then what the hell does she want? And that was the question, wasn't it? Because Victoria hadn't asked for anything, which meant she already knew she didn't have to. The door to conference room Arcshire slammed shut like a coffin lid. Inside, the temperature dropped 10 degrees and not from the air conditioning. Meredith Liu, the company's lead counsel, stood at the head of the table, eyes sharp, jaw locked. She wasn't wearing her usual courtroom smile or corporate charm lipstick. She was wearing war paint, subtle but unmistakable. Brian, Karen, and the full compensation committee were already seated, water untouched, notepads unopened. The silence was thick enough to stir with a fork. Let's get one thing straight, Meredith began, pulling a stack of printed documents from a leather folio and slapping them down like evidence in a criminal trial. This isn't a miscommunication. It's not an HR oversight. This is a ticking liability with a lit fuse we lit ourselves. Brian leaned back, trying to play it cool. Look, we know she's making noise, but she's bluffing. She's always been dramatic. She's not bluffing, Meredith snapped, louder than anyone expected. And this isn't drama. This is contractual suicide. She opened the folder and pulled out a single page, sliding it across the table to Karen. Page 6 of the Q4 amendment. Your signature. Karen didn't even look. I didn't read every line, you initialed every line, Meredith cut in. And so did Brian. You both signed off on Clause 11C, including the activation multiplier language, the vesting window clause, and the constructive termination trigger. Constructive termination? Brian repeated, brow furrowed. Means you fired her under circumstances designed to avoid paying her a contractual obligation, Meredith explained. Which, in the eyes of the law, is the same as firing her because of that obligation. Karen paled, but we fired her for restructuring. We didn't mention the bonus. That's precisely the problem, Meredith said. There's no cause documented, no performance flags, no disciplinary notes, no redundancy justification filed with HR. We walked her out 23 hours before a scheduled equity vest, without reason, and thought that would void her bonus. What it actually did was activate every financial protection she embedded in that clause. She turned to the rest of the room now. Gentlemen, ladies, this was not just a poor decision. This was a $6.5 million trigger wrapped in arrogance and fired like a starter's pistol. One of the committee members cleared his throat. Is this enforceable? Beyond enforceable, Meredith said. She has timestamps, backups, email trails, and metadata. Her termination was filed internally 37 minutes after she submitted her clause to legal and compliance. That creates the impression, legally and publicly, of retaliation. Brian muttered something under his breath and pushed his chair back like he was about to walk out. Meredith raised her voice. Sit down. He froze. He'd never heard her speak to him like that before. Meredith walked slowly to the touchscreen at the head of the table, tapped in a command, and brought up a document on the 80-inch display. The original equity agreement. Scanned. Digitally signed. She zoomed in. Clause 11C. In the event of involuntary or constructive termination within 24 hours preceding a scheduled equity vesting event, the subject shall be entitled to full vesting acceleration, immediate payout at current market value, and additional compensation calculated at 1.5x base salary. Arbitration shall be waived at the employee's sole discretion. A silence fell so loud it roared. Who the hell approved that clause? Someone whispered. Meredith tapped again. A signature line filled the screen. Board Chair Lawrence straightened. The room let out a collective groan. Brian's eyes went wide. Wait, Lawrence signed that? He did, Meredith said, back in 2019, before we'd closed Series B. Victoria wrote the clause as retention insurance. Lawrence agreed it was fair given her role in structuring our early compliance infrastructure. It sat untouched for 3 years, and now it's about to cost us the GDP of a small nation. Karen, barely above a whisper, why didn't we catch it? Meredith's voice dropped to a deadly calm. Because you never read the fine print. You were too focused on headlines and handshakes. Meanwhile, Victoria was writing her escape plan in plain sight. In ink, with your initials. The committee shifted uneasily. Someone finally dared to ask, is there a fix? Meredith shook her head. No clean one. If we try to settle now, it'll signal guilt. If we go to court, we'll lose. If we stall, she can escalate to the board. If we try to retroactively justify the firing, she's got version control data on every document, including yours, Brian, locked in her personal legal archive. She's been 10 steps ahead since the moment she handed you her badge. Brian slumped back in his chair. What does she want? Meredith stared at him. She doesn't want anything. That's the part you still don't get. She doesn't need anything. She already won. The call came in just after noon, while Victoria was sitting alone in the rooftop garden of her condo building. Her phone buzzed once, then again. She didn't recognize the number, but she knew who it was before she even touched the screen. There was a specific flavor of corporate panic that only came from the upper echelons, the kind that vibrated through glass and steel and bonus structures. She answered on the second ring, calm as ever. Victoria Owens, she said, sipping her tea. Victoria, the voice said, cool and composed, but just slightly frayed around the edges. It's David Halpern. From the board, she smiled faintly. Halpern had once offered her a position at a rival firm, directly, discreetly, and with enough zeros to make her pause. He'd always had a decent radar for where the real power lived in a company, and she suspected that's exactly what prompted this call. David, she said warmly. To what do I owe the pleasure? I'll get to it, he said. Did you intend to trigger Clause 11C? She didn't even blink. They terminated me. I just made sure I left a paper trail. A silence thick and thoughtful, she let it hang. I've read the clause, he said finally. The annotations, your timestamps. Frankly, it's one of the cleanest risk shields I've ever seen embedded in an incentive package. I had good mentors, she said, some of them on your board. He chuckled under his breath, not joy. Admiration edged with dread. Brian still insisting it was an oversight. I'm sure he is. Karen's claiming she never understood the multiplier. She understood enough to sign it twice and push it through without review, Victoria replied. That memo she sent on December 14th? I flagged the language in bold, underlined. Her initials are on the margin. Timestamped. Metadata intact. Christ, David muttered. Another pause, then a different voice entered the background. Muffled but urgent. David, she didn't just trigger the payout. There's a secondary multiplier tied to the equity value ratio. Just recalculated it. Victoria waited, listening to the scramble like it was symphony. 6.4 million, the voice said. Possibly more, depending on the market value recalibration at the time of termination. David came back on. Our CFO just confirmed what legal was afraid of. Because of the clause's reference to unvested equity and the 1.5x multiplier, your payout is actually above 6 million. Victoria didn't respond immediately. She was watching a pigeon pace along the railing like it was conducting a board meeting of its own. David, she said calmly, you're not calling to debate the payout. You're calling to assess the fallout. I'm calling, he admitted, because Karen is about to be thrown to the wolves and Brian's pretending he can't hear the howling. Meredith wants to settle, but you haven't made a move. No counteroffer, no statement, no lawyer. Why? Victoria leaned back in her chair. Because I don't need to. I played this by the book. I wrote the book. They just forgot I never stopped editing it. David exhaled long and low. They'll ask for arbitration. They can request it, she replied. The clause gives me sole discretion to decline. Litigation, she shrugged. They'll lose. The documentation's airtight, and they know it. That's why Meredith hasn't reached out directly. She's buying time, hoping I flinch. You won't, he said quietly. I haven't yet. Soft laugh. You know, Victoria, you always struck me as too composed for this business. Too methodical, but watching this unfold, I realize now that you weren't calm because you lacked fire. You were calm because you knew where every fuse was buried. That's why they hired me, she said, and why they shouldn't have fired me. The line went quiet for a moment. Then David said, I assume you'll be getting counsel involved eventually. I already did, she said, 3 years ago, and I wrote Clause 11C. Click. End call. She didn't smirk, she didn't gloat. She simply looked up at the sky and watched the clouds pass overhead. 6 million was never the point, not really. The point was they built an empire on her spine and thought they could kick it out from under themselves without consequences. But Victoria wasn't angry. She was precise. And precision always finds its target. The executive suite was dead silent, unnaturally so. The kind of silence you only get after the last champagne bottle's been emptied and someone finally notices the floor's on fire. Everyone had been summoned. No agenda, no coffee, just a hastily booked leadership sync that smelled more like a trial than a meeting. Brian sat at the head of the table, jaw tight, arms crossed like a teenager sent to detention. Karen sat to his left, visibly trembling, legal pad in front of her with nothing written but the word defensible in 5 different styles of handwriting. The CFO was ghost pale. The head of HR looked like she was rethinking every career choice she'd made since college, and the only person moving with purpose was Meredith Liu, lead counsel, and currently the only adult in the room. She dropped the packet on the table like a gavel. You've all read Clause 11C, she began. But allow me to read it aloud. One final time, so there is no further misunderstanding about what has just occurred. She didn't wait for permission. In the event of involuntary or constructive termination within 24 hours preceding a scheduled equity vesting event, the subject shall be entitled to full equity acceleration, compensation equivalent to 1.5x base salary, and associated damages as calculated under the pre-approved performance incentive plan. Employer waives arbitration in the case of demonstrable bad faith dismissal. She closed the file, slowly removed her glasses, and turned to Brian like a firing squad lining up its first shot. Brian, her voice was low and cracking. Please tell me you paid her. Brian blinked. Excuse me? Meredith stood straighter. Tell me right now that you issued her the bonus before the termination went through. He shifted in his seat. We terminated her before it vested. That was the point. The room went still. Jesus Christ, Meredith whispered. I mean, he added, palms up, if we fire her before the bonus vests, we don't have to pay it. That's how these things work. Everyone knows that. No, Meredith snapped loud enough to make Karen flinch. That's how you think it works. That clause wasn't written to avoid payment. It was written to protect the employee from exactly that kind of maneuver. The CFO looked up now, eyes haunted. We've already received a notice of intention to collect damages. It came through 2 hours ago. Her counsel submitted a certified statement with backup files, timestamps, internal emails, everything. Brian scoffed. So what? We counter. Negotiate. Offer half no, Meredith said. You don't negotiate with someone holding a loaded contract and a detonator in the other hand. She doesn't need to talk, she just has to wait. And right now, the board is demanding to know why you authorized a termination without legal review or just caused documentation inside a protected clause window. Brian's smirk was fading now. Okay, so we pay her the bonus. Worst case, 4 million. Meredith turned to the CFO. Tell him. The CFO's face was grim. With the equity recalculations, performance triggers, and multiplier clause, Karen let out a strangled whisper. Multiplier? The CFO nodded. It's not 4 million. It's 6.5, and that's before damages. Brian leaned back in his chair like he'd just been hit with a sledgehammer. You can't be serious. She even submitted the meeting transcript from the Q4 session, where you dismissed her clause concerns on record, Meredith added. We're talking about